before we get go, let's go.
Hi, my name is Will Flanagan, and I'm the sales manager for the Fogg Miranda team at Keller Williams Burbank. And I'm here today with the leading expert on fire litigation. Chris Hendricks is with Fox Law. Chris has been practicing law for a long time and specializing in fire litigation for what, Chris, over 10 years, I believe. So I
It's
wanted to,
just under 10 years, nine and a
just
half
under
years.
10 years. Long enough to know the ins and outs. And that's why I wanted to do this little video. I want to share some of this information that you have, in particular with the people in the Eaton Canyon, the Altadena fire victims, fire survivors, as I was corrected today, because they're not victims, they are survivors. But go ahead and introduce yourself, a little bit about your background, and help us understand the process that people are looking at and some of the considerations they have if they are, especially homeowners who are, in the midst of dealing with insurance and potential litigation with a third party.
Of course, yeah. And thanks for having me here. I'm happy to talk about this. Like Will said, Chris Hendricks, I'm an attorney over here at Fox Law. I've been in practice for a little under 20 years myself, and we've been doing fire for right around 10 now. We got involved in the Butte fires up in Northern California. That was about 9.5 years ago, and we worked about 25 fires. Since then, we've been on leadership for almost every major wildfire in California during that time, and we are leaders in the space. We've been doing this well before the Eaton fire, and we'll be doing it long after. So, one thing I think that you were saying with insurance, I think the biggest thing is to get those claims going, is to get the insurance money into people's pockets as soon as possible. You paid for that insurance. Most people that we see in the Eaton fire are substantially underinsured, both in terms of contents and dwelling, and ALE for that matter, or loss of use. So we always say take the steps you need to do to get those funds, whether that's itemize the contents of your home or just request. And we always say my biggest advice to dealing with insurance companies is any conversation you have on the phone, follow up with an email and writing to your adjuster saying, just to reiterate what we said today, I asked you to say, for example, adjust the dwelling of my home. I would like a response on that. I'd ask you to adjust the contents. Here's the information you requested. And I'm seeking X or Y or Z in terms of the ALE for a rental or replacement property. So getting the ball into their court so that they have a time that's ticking to respond to you and get that money out the door into your pocket is the first step of these claims.
Got it. I guess one of the questions I have, I want to talk to you about is people are asking me, well, how long is this going to take? And, who is the potential third party or third parties that you guys are looking at?
Yeah, so there's no way that I can give an exact estimate on how long, but I can give you some parameters on what we see in these cases. Is the shortest fire we've ever been a part of took about a year to start resolving cases. That was a much smaller fire than Eden. So I don't think that's really a realistic possibility here. It's always could happen, but I don't think that's expected. The longest we've seen were the North Bay fires against PG&E. Those took about 5 years to complete, or to really get a lot of settlements done. I think some people are still probably working on those. We were able to resolve all our cases a while ago. But in that sense, that case had an intervening bankruptcy of PG&E, which made those cases take a little bit longer. I think the 2.5 year to 3 year range is when we'll start seeing cases resolved with some degree of quantity in this Eaton fire. I think that's a reasonable time frame. And obviously, the biggest thing that gets these cases towards a settlement protocol is having trial dates approaching in court. That should usually take a little over 2 years to do. So the lawsuits are filed. We have filed our lawsuit in Eden, and we do expect that 2.5 year range should be pretty reasonable for seeing some settlements start happening with a degree of regularity. In terms of the defendant, like I said, we have filed our litigation on behalf of, we represent over 500 clients right now in Eden, and that's growing. Southern California Edison is the primary defendant. And what we know there is we do think there's a good liability case against Edison. We do know that this fire originated in Eaton Canyon on Tower 3, which we're referring to as the baby tower. It's the smallest of 3 towers over in Eaton Canyon. And there was an arcing event. A lot of people have seen the video from the gas station showing the arcing event. Subsequent to the arcing event, there was the vegetation below it lit on fire, and that's where we believe, and our experts have already opined that that's where the fire started. So we're feeling pretty confident about causation and that SCE is at fault and was not only negligent but liable for inverse condemnation in this case.
Got it. Now, if I'm a homeowner, what do I need to do if I'm not part of a settlement litigation? What evidence do I need to gather? How would I reach out to you? What's the difference between going with you and trying to do it on my own, or hiring somebody else who, my cousin who practices, I don't know, some area that's not specifically geared towards this?
Yeah, so I haven't run across too many people doing this on their own in any sense. So this usually requires a lawsuit filed that's going to be part of what's a JCCP or Judicial Council coordination proceeding in Los Angeles Superior Court. That's going to take, there is going to be a degree of litigation to take depositions, to do our liability case against Southern California Edison. So I don't necessarily think there's a good option to do this alone, unless you're maybe a very talented attorney in your own right and can join the JCCP that's going to be coordinated here in the next couple of weeks. I always say it's very important to go with a qualified firm. I would always look to a firm that's had experience in wildfire, and maybe not just one or two fires, but I would look to make sure they've done 5, 10, if not more fires. This is not the easiest area of law. It takes a tremendous amount of knowledge and resources to get these claims going and to get them resolved on a very good basis to make sure we're getting at or near full value for clients' claims. So my biggest thing is talk to these attorneys. There's no immediate rush to do this today or tomorrow, but I would say in the next 60 days, you should probably settle on an attorney that you feel comfortable with or a firm you feel comfortable with in a long-term relationship. And like I said before, 2.5 to 3 year frame seems pretty reasonable for cases getting done. That's a long relationship. So make sure you're comfortable with them. You can talk to 2 or 3, but if you feel comfortable, I think at that stage it's worth proceeding. And then what these cases are doing essentially is obtaining the amounts that are uninsured or underinsured damages against Southern California Edison. So a lot of people are underinsured, and some people are even uninsured entirely. So you're able to get those amounts. And I would say our firm specifically, Fox Law, we do not take a part of any insurance recovery. That is the norm in this field, is to not take a part of first-party insurance recovery. That should go to the people who paid for it, which would be the survivors of the Eaton fire. I would make sure that anyone who's interviewing a firm gets that in writing in the representation agreement, that this is not meant to take a contingency fee percentage on any portion of the proceeds from a first-party insurance claim.
Got it. One of the things we talked about before that I think is really important to share is, I think the term of art that you referred to is diminution in value. And for the layman, I don't remember if I told you, Chris, I was a lawyer a long time ago. But I still think it's important for us to speak in plain language so that the non-lawyers can understand what that means and how that affects people who own property. Now, I just read an article in the paper about a colleague of mine who I know, who represented the property. His client sold a plot of land that had been burned in Altadena. And how do those sales right now that are taking place, whether it's a listing or an actual sale, how is that going to impact any future settlement that they might obtain from Edison or any other party?
Yeah, so this is probably, it's a great topic to raise because it is probably the single most important thing in these wildfire cases. There's essentially 2 measures of damages for the loss of a home or a property, and that would be whether you're going to obtain restoration costs or diminution in value. I always say diminution in value, the best way to think about it is what was the property worth the day before the fire and what's it worth the day after. So just giving an example that's not particular to any one case, if you have a property that's worth $1 million, which a lot of single family homes in Altadena were around that range, and it was lost in the fire, maybe the day after the fire, there's a developer that will still come in and buy that lot for $650,000 and rebuild it and put up a twin home or some other development, something that they think they can make profitable there. The diminution in value there is that delta of the $350,000 that was lost. That is not the best claim to go after. The best claim to go after is the restoration cost. That's what does it cost to restore that property to its pre-fire condition. And that it would cost whatever it does to rebuild that property. Say it was a 2,000 square foot home. What does it cost to do that? Well, we know right now that estimates are coming in the 700-800, if not more, depending on the property, per square foot. You do the math on that, you're well over that $350,000. Not to mention the landscaping, any trees, irrigation, erosion, subsidence issues that may come back. Those all go into restoration costs, and they are not calculated in diminution in value. The only thing you need to have to go after the restoration cost is what's called in law a genuine intent to restore the property. It's not measured by actual progress of starting to build. Most people can't build until the cases with SCE are resolved. But what you can't do if you want to go after the restoration cost is sell the property one. That claim's over once the property's sold. But I would also highly advise against listing it for sale or telling your insurance agent that you don't plan to rebuild. During the pendency of these cases, at some point, there's going to be a file from your insurance company that makes its way to SCE because they're going to be seeking their subrogation costs, essentially the cost that they pay the victims in first-party insurance. And they're going to seek that back from SCE. So their files go over to SCE. So they're going to know if you tell your adjuster that you don't want to rebuild. So until you really thought that through with the knowledge that it could severely impact your wildfire claim, I would advise to not list your property unless you're sure that that's what you have to do or that that's what you want to do. And don't tell your insurance adjuster the same thing. So I would just keep that decision mulling it over, and you got to think about it with knowledge of how much it's going to impact your claim.
Got it. Now, another question I had, and I just have no idea, if somebody has an insurance policy that's going to pay them, let's say their property was valued at $1 million and they had $1 million insurance policy, and they get a full payout from their insurance company. Are they going to have any settlement that they get from Edison or whoever offset by the amount that they got from their insurance company, or reduced?
Yeah, so it will be reduced. And essentially, all we do in the lawsuit is actually seek the delta, seek the difference between what they get and what the actual full value of their claim is. So even if if your contents are insured for the full value of the property, according to the property value, we still find that that's not enough to actually rebuild the property, that restoration cost that we talked about. So there is still value in the claims against Edison. On top of that, there's some items that are extremely underinsured on a insurance policy. If anyone's dealing with this right now, you're going to hear things like separate structures, like you have an ADU or a garage that might be insured for $40,000 or $50,000, and there's no way that gets rebuilt for that price. The other would be landscaping, usually has a very small amount. Another one would be trees. Trees are usually $750 or $500 a piece on an insurance policy. To replace some of these beautiful trees in Altadena, these mature oaks, pine trees, there's a lot going on there. Those can be $5,000, $10,000 plus, and some people have literally dozens of these on their property. So that can be another substantial portion of the claim that is significantly underinsured in almost every case we've seen.
Got it. Now, can people go after other damages, emotional or psychological damages, or any maybe physical damages if they're dealing with any health issues that are resulting from this fire, or if they've lost income because they can't work from home anymore and now they have to rent an office? Can they go after these other items in the settlement, or is this strictly a settlement that's going after the loss of the property?
That's a great question as well. So if you suffered physical injury, that case is valid for you're paying, you're suffering the actual medical bills, everything like that. And there are, sadly, I think it's 17 wrongful death cases resulting from the Eaton fire at this point. And these people lost their lives, and it's terribly tragic. But those cases, even regardless of whether they own property or not, are certainly able to be brought against Southern California Edison. If you were injured, the same thing. But even if you just have the emotional distress of losing your home, losing your rental property, there's a category called annoyance and discomfort of damages that are available in this type of claim. So if you had to, things that would go into that are if you had a harrowing evacuation where we talked to a lot of people that barely made it out or were fighting the fire till the end and had to leave. Another one that we see is people have to switch schools. They're out of their property for 3 to 5 years. things like that get into that annoyance and discomfort category. So yeah, you can pursue those whether or not you had a home. In fact, a lot of people who are bringing those claims were essentially just residents of a home. They didn't actually own it themselves. So that is a valid claim, and that's a good point as well.
I have a client who unfortunately lost uh, their home, a couple homes actually, and one of the homes was an art studio. He's a very well-known artist, and all of his, not all of his, but a substantial portion of his prized art that he produced was lost. Um, how would they value something like that that's unique to that particular person? Is that something that's going to be a separate claim?
So in addition to so artwork, you usually use an appraiser. There's a fair market value for most artwork. There's also another category of damages that can be pursued against Edison in these types of cases, and that would be what's called cherished possessions. Those are items that may have an actual value to you that's in excess of what it would be in the outside world. And the biggest things I think of that, think photo albums, a wedding dress, and a family heirloom. Those kind of go into that. When I hear artwork, generally, if these actually have a real fair market value, and you can have a cherished possession, artwork that may not have a lot of fair market value out there, but meant something to you. Maybe a family member painted it for you that's since deceased. But most artwork that's commercially sold, we can hire an appraiser, and we do this quite frequently to value that piece of artwork.
Yeah, this guy, he would be fairly easy to value because he has a history of, being commissioned on different pieces, public art pieces, etc. So yeah, I'm sure. I think he may have already contacted you, but if not, I'll make sure I have follow up with him. I don't have any other specific questions right now.
I
That
think
I
there's one thing that I wanted to touch on that you mentioned, and I think I kind of dropped the ball on it, but there are business loss cases here as well. Um, think things where you may have lost your office or your ability to conduct business because of the fire. So we have everything from we have somebody who was in Hollywood adjacent, essentially a costume designer, but it was a medieval timepiece kind of materials. These were collected over from Europe over a period of decades, and that's what she used to design basically set pieces for Hollywood. Now, those all burned up. You can't just go replace those items. It's going to take a while to do so. So there's a huge impact to our business for years to come. So that's something that you're able to pursue. Additionally, we represent assisted living facilities and the loss of ability to do business because the property burned down. So things like those cases are viable as well. Even if the business was just renting the property, if they're unable to conduct business or there's a substantial business loss, those are viable cases against Edison as well.
Got it. Now, if you've received money from either an SBA disaster loan or a GoFundMe or some other charitable organization has given you funds for whatever reason to replace a car, to get housing, do those funds get offset by, does the settlement that would come to them say, well, you received $100,000 in funding, or you got a loan for, X number of dollars. So we're gonna lower the amount we offer you because you received a loan from the SBA or something?
No, so there's a rule in California, and I don't want to get too granular. If you're not an attorney here, it's called the collateral source rule, and essentially says if you receive recovery from another source, whether you paid for it, whether it's charitable, anything else, that should not inure to the benefit of the wrongdoer. The wrongdoer here being Edison. So they can't take advantage of your parents, a charity providing you with housing, anything like that, and offset the amount they owe. California says that's unfair, and that's a very well-established law. So I would say be encouraged and free to take anything that you're being offered in a charitable sense.
Got it. Now, this is maybe not in your wheelhouse, but you may know enough to opine on it. A lot of people currently, their house is gone. They still own a mortgage on their house. I know there's a forbearance that's been in place and it's going to be in place for several more months. How can people extend that forbearance or get a deferment on that repayment of that mortgage? And part two, which is maybe a much more difficult question, how have you seen, if you've seen this at all, somebody be able to go out and purchase another house while they have a property in forbearance on a, from the fact that they don't own a house anymore, they own land, but obviously the value that obtained the mortgage on is no longer there, but yet they're still liable for that repayment. How does that kind of get calculated in? And do you guys ever work on those kind of, I guess these are thorny financial questions, because there's people that I've talked to that would like to go out and purchase a new home, but they're looking at, an $800,000 mortgage that's hanging over them. And I don't know how to help them, honestly. And so I don't know. There are some lenders who are kind of coming up with some creative workarounds. But have you heard of anything like that, or seen people work through that?
Yeah, and so I guess there's two questions here. Is in terms of forbearance, the best policy is to just ask, contact your bank, see what they're offering, see if you can negotiate something. That's a creature of negotiation. Most major banks are offering some degree of forbearance here, and they're usually kicking out 30, 60, 90 days, and then they're dealing with the next steps at that time. Now, people who are, when you say to buy a new house, that again has to just depend on the lenders themselves if you need to finance the home. When the way the insurance money is coming in, if people are getting a decent degree of insurance money, maybe not enough to rebuild, but certainly probably enough to put a down payment on a home and start financing something else. So if those funds do come in, you can use some of it as the down payment collateral. You do always have to just understand that for at least the dwelling portion of the coverage, a lot of times your mortgage holder will actually have first priority to the amount up to the level of the mortgage that's remaining. So everything there is pretty much a negotiation. But I would say the biggest thing I've seen is people taking some of their insurance funds and just using it to put a down payment down and finance another property.
So I know we talked about this before. So it would be something that a person might be able to negotiate and say, look, my living expenses that you were going to provide for me to go out and rent a house, a lump sum of, $250,000. However, I want to use that, break it up over a year, 2 years, whatever. Maybe I'd be able to negotiate a lesser amount to get a cash buyout for that. Is that correct? Maybe.
Yeah, or even the full amount. So like,
Or
let's
even
put
the
it this
full
way.
amount.
Say you lived in a property that would easily rent for $10,000 a month and you had $200,000 of loss of use coverage. It doesn't take a genius to figure out that property's not getting rebuilt in 24, 25 months. So you say, hey, just pay me the entire amount. I'm going to use that for a down payment somewhere else. And we have seen insurance companies be pretty good with that because in this case, there's not going to be any insurance adjuster that's credibly going to argue you should be rebuilt in a year. It's just not in the cards. They understand that. So that's essentially with a policy too. That's where you get the most wiggle room is in that ALE loss of use category. So yeah, I think it's always worth having that conversation and seeing if they're willing to do that because they're either going to spend it on the down payment for your new home or they're going to spend it on your temporary housing. So for them, I don't think it's always going to matter a ton.
And is that separate from the amount of the replacement rebuild cost? So if the rebuild portion is $1 million and then you get a separate chunk for the all living expenses, they don't get combined together, do they? They're separated out, right?
In almost every policy, they're different coverages. So your dwelling coverage is going to be different than your loss of use or ALE coverage. Just like in these cases against Edison, we'll have a different number for the structure itself for replacing for redoing the house, but there'll be a different number for the loss of use of the property and any living expenses that you had to incur above and beyond your policy.
And then there'll be a different number as well for people who, their furnishings and their personal items. I mean, some people, there's going to be some women who are going to be like, I had, 1,000 pairs of shoes.
Yeah, and I've already seen some of the
right?
claims with handbags that are worth $1,500 each, and they had 30 of them.
Right.
That is something that we see quite frequently. So there'll be a different number on that in the claim against SE. There'll be a different number for that annoyance and discomfort that we talked about before. So yeah, we work up every aspect of the claim, just like there'll be a different number for landscaping, arborist, different things like that. So yeah, we do take great pride in working up every single aspect of the claim because there is value in making sure that every aspect of a claim is worked up.
Got it. Now it seems like, there's a lot of aspects to this. It's very complicated. So we're going to wrap up here, but I just want to thank you and go ahead and give your contact information so that people can reach out to you directly if they have questions or if they want to follow up or reach out to you.
Yeah, thank you for having me here today. It's I'm happy to help, happy to answer any questions. My email is Chris, CHRIS, at foxlawapc.com. And my direct line is 760-840-6552.
Great. All right. Thank you so much, Chris. I appreciate your time. And
Thank you, Will.